Good evening and welcome to Defense Diaries. Today is what is it, babe? July 30th,
Yes,
2025. And I am your host, Bob Mata, and I am joined once again by my beautiful and brilliant co-host for our continuing coverage of the Karen Reed trial / aftermath. Hey, what's up, babe?
Hey, babe. Hey, all.
So, been really looking forward to this. I've been trying to wrangle both Bob Alessi and David Atty for a minute since the trial. They've been very busy. First and foremost, trying to get their practices back in order after a year or so, devoting all of their time to Karen Reed's case. And we as attorneys obviously can understand all the logistics that come along with that. Plus, it was an exciting time, and we'll ask Bob this, but when you try a case like that, it does take a lot out of you. Now, whether it took anything out of Bob Alessi is a different story, but he is our guest tonight. We are extremely happy that he's here. We're very thankful that he's here.
I just want to say that if you give supers, we are going to try to incorporate them organically, and then they'll all be addressed at the end. So don't worry about that.
Yeah. And so as far as Bob Alessi, I mean, you know him, you love him. If you follow Karen Reed, you know exactly who he is. You know exactly what he's about. If you don't know, he's, I believe he's a partner at DLA Piper, a big, huge New York firm. And the guy's just an amazing attorney. And I don't think that we need to waste any more time. Let's bring him right
but
up.
I just want, okay.
What were you going to say? Go.
Oh, I was just going to say that, this isn't just about the Karen Reed case. It's about what the case reveals about the system we work in, we push against, and sometimes survive. Karen Reed's case exposed deep cracks in the justice system. So we're not here to relitigate the facts. We're here to have a broader discussion with a lawyer who just fought the fight of a lifetime. We're going to do this more as an open discussion format. So grab a chair and join us for a roundtable with Bob Alessi.
Wow, I'm glad I waited for that. That was really powerful stuff. Deep, very deep stuff. Yeah, and I will try to talk less and let Bob talk more, just for the record. Let's bring him on. Bob Alessi, thank you, my friend. We're so excited to have you. Welcome.
Well, thank you. I'm very excited to be on your show. I watched it during the trial, so it is great to now be on your show and be talking about all things that are relative and probative for you and your viewers. So happy to be here. Thanks for having me on.
All right, and I have to tell you, I'd be somewhat remiss. I have to make an admission, which I'm not afraid to make, but during the pre-trial phase, I did develop a pretty massive man crush / law nerd crush on you. So if you catch me during this live gazing upon you with starry eyes, I'm apologizing in advance. Okay. So I just wanted to lay that out there. I think, all of our subs and our followers know that, I had big love for Bob Alessi, so I'm really happy you're here. I'm excited for this conversation. And look, I mean, you have made having a robust vocabulary very cool. So I thank you for that, because you're bringing big words back, Bob, and I'm a big fan of big words. So I think that, like, where I'd kind of like to start with this, I'd like to kind of get some of your background. I'd like to know a little bit about what makes you tick. Why don't you tell us a little bit about your childhood? You don't have to go too deep into it, as deep as you want to go, because
Lay down on the couch.
yeah, lay down on the couch and let's dig in. Let's dig into that big brain of yours, and just so you have brothers and sisters. Tell us about your folks. You know, where'd you grow up? All that kind of good stuff.
Yeah, I had a fantastic childhood, lower to middle class, upbringing in upstate New York and central New York. My father now refers to it as a third world country in central New York. But when I grew up, it was a factory area, great people. Just one of those environments where, to use the tired cliche, the parents would open up the door in the morning, particularly in summertime. All the kids in the neighborhood would go out, and then, somebody's parent would feed you, depending about what house you were at lunch. And then you go home for dinner, you go back out. So it was fantastic. I had many varied interests. I loved sports. We worked on cars. We were car nuts. It was a lot of rural area, so there's farms all around. So we just had a great time, rode our bikes, sort of typical childhood. Education was something that was not an option in my family. My father had a rule that if you were not on the honor roll, you were not playing any sports. And so it was a great incentive for me. I had an older brother, a younger sister, mother and father, and ended up going, fortunately, even though the area I grew up in, to one of the top ranked high schools in the state, because Oneida Silversmiths was back then robust. It was a company that made silverware, and they came from England, and brilliant people, and they established a community, and they essentially established the school and ran the school. So I had a fantastic public school system. So to me, my childhood was great. A lot of great friends, a lot of great people, a lot of salt of the earth people. You just learned about honesty. You learned about hard work. You learned about having people's backs. You learned about supporting people when they were up or down, particularly when they were down. In my community, everybody went and picked up that person. And there were a lot of things that I learned that I carry with me today.
Yeah. And did you, it sounds a lot like my upbringing. Obviously, I'm 55 myself. So, that concept of, you were out all day playing. We lived in a much different time when we were children. And obviously I was out all day. The rule was come back when the street lights come on. And, there was that feeling and that sense of neighborhood and community that doesn't really exist in the same way anymore, which is a shame, but it did really instill a lot of those kind of values in you in terms of, just forming who you're going to be as an adult. And, so in terms of your sports, what did you play? What were your sports?
Well, the main sport was boxing. My father was a Golden Gloves. His father, my grandfather, was a boxer. He trained with Jack Dempsey, a renowned heavyweight champion. My mother's side was boxing. Her distant cousin was the middleweight champion of the world, Carmen Basilio, one of the few people to beat Sugar Ray Robinson. So I was in a gym when I was 4 years old, and then started competing in boxing when I was 9 years old. Had my last bout after 3 family interventions in 2015.
Wow.
So boxing was my sport, but I played all kinds of sports. Baseball. I played football till I got a knee injury and switched to soccer. Played basketball. I actually lettered in 6 sports because my school let me do 2 sports at a time for 2 seasons. Absolutely loved sports. So that was that. And another thing that was really important in our community was people worked, kids worked. I mean, you know, everybody, you did something, but I had a paper route with my brother when I was 11 and never stopped working, you know, worked in a kitchen at a racetrack. And I think that was also very, very important growing up is just working and the personal reward of making your own money, having a little bit of money in your pocket, but just accomplishing something and a little bit of discipline. So sports was everything to me. And if I got to tell you, if it wasn't for my father's rule that I had to be on the honor roll
I was
to
going to
play
say,
sports, I don't know how much time I'd have paid attention to school.
Yeah, I mean it's a pretty solid rule to keep your nose at the grindstone, you know. And as far as the athletics go, I mean, I had written a question out. I'm like, when you were so my wife, when she was 5 years old, and I've seen the written proof of it, you know, she had written, maybe she was 5 or 6 or 7, maybe she was able to write. And I read this little note that she had written, and she had talked about even at that age that she wanted to be a lawyer when she grew up. Now, was little Bobby Alessi running around the house saying, "Hey, I want to be a lawyer when I grow up," or is that something that you kind of figured out as you got a little older?
Yeah, it was much the latter. I couldn't look beyond whatever sports season it was to even think about school, let alone a profession. It was just, and I really didn't aspire to be a professional athlete, although I deluded myself that I might possibly be one. I just was kind of in the moment when I was growing up, whatever sports season, that's what I got excited about. And I really didn't look beyond it. So becoming a lawyer didn't become something of interest to me until much later than in life.
Yeah, that's amazing. The boxing thing is kind of blowing my mind. If you guys don't know who Sugar Ray Robinson was, I suggest renting Raging Bull. It's a Robert De Niro movie. It's also got Joe Pesci in it. But some of Jake LaMotta's most vicious fights were against Sugar Ray Robinson. And it's that one famous scene where they show the rope of the boxing ring just saturated with blood dripping. And that's when De Niro turns to him. He says, "You never got me down, Ray. You never got me down." So that's the person that Bob Alessi was talking about. That you said that was your mother's father?
cousin.
No, it's my mother's distant cousin.
Wow.
So they all grew up in Canastota, New York, which is where the International Boxing Hall of Fame is located.
Wow. That's amazing. That is amazing stuff. So as far as like, I want to get into your entertainment side a little bit. We're going to get all the background on you, and then we'll move into the juicier stuff. But do you consider yourself a movie guy? Do you like watching movies?
The answer is I don't dislike movies. I just don't have a lot of time to watch movies. Every once in a while, I get tied into a series, and so movies is not it. But for example, for some reason, I got very much interested in Bosch and Bosch Legacy, and then my current one, although I haven't had much opportunity to get into season 3, is Reacher. And that's the one with, I don't know his name. He's the big guy. It's not the Tom Cruise Reacher. It's on Amazon Prime. But that's what I have. I do a lot of reading. I love to read books, and that's where I spend most of my time. But I get needled by friends and family if I spend too much time reading and I can't answer basic questions about like what are the most popular shows. So I cheat a little bit. I read summaries and then I try to pretend like I watch them.
Well, someone in our audience, Laura A, she said she wanted to let you know that her dad and his friends put money together to start Ray Leonard's career, or to get his career started.
That's pretty cool. Wow, that's amazing.
That is amazing. If I recall correctly, I think Ray Leonard wasn't he from the Maryland area or something? So that's something. Let me tell you something. Boxers always need money. That's a whole nother story.
Yeah, the first Ray Leonard, actually it was Ray Leonard versus Marvin Hagler, was the first time that I had ever seen. Like it was an event that they held at a theater where it was kind of the first pay-per-view thing that I'd ever seen, and it was pretty cool because that was a big fight back then. So what about What about music? Are you a music guy?
He loves it all. I've heard him say it. Everything from
Yeah. Please go ahead, Allison.
no,
Yes.
no, it's your story. I don't know why I was chiming in, but I was so impressed with your
No,
span
no.
of music.
Yes, I'm always interested in what other people hear about my likes of music because it's usually on point. I
It was
love
what you said
music.
on
I
Melanie's
have
show. You went into it, so that's where I heard it.
yeah. I have music on virtually all my waking hours, and it's very eclectic. I have a bit of a routine, although it's not etched in stone. I get up in the morning, I turn on classic rock. I non-sponsor Sirius XM, but I love Sirius XM because of the variety. So I'll put on 26 classic vinyl and listen to rock. I love 60s and 70s rock, but any kind of rock. And then as the day goes on, I'll switch over. I'll switch over to usually some classic rewind, which is 80s. And then for my rest of the day, and particularly for workouts, I do lithium, which is 34, which is grunge rock. It's 90s, Red Hot Chili Peppers, Soundgarden, that type. That's probably, I vacillate, that's probably my favorite right now. When I'm doing work, which is a lot, it's all classical music. And it depends, but I'll do whatever I have on Spotify, my list. But I also I think it's 78 Symphony Hall on for the classical music. And then for some reason, it's probably my father because he does this. At nighttime, like when I'm getting ready to retire, I listen to oldies, 50s and 60s music. So it's very eclectic. And then throughout the day, when the mood hits me, I love hip hop. So I'll do Biggie Smalls. Mace was one of my first hip hop, Harlem World album. I was pretty much into that a lot. So I love hip hop as well. So pretty much it's the gamut. Music is huge for me. Nobody should ever have to hear me sing, but I love music.
We are lovers of music as well. I was putting my Pearl Jam 20 there since you said you listened to lithium and grunge rock. But so no country, or do you do country?
I'm not adverse to country, but the closest I come to country is sort of, what is it, Kenny Chesney, a Blue on Black, that type of music is close. I don't dislike it. I just haven't yet fitted into my sort of routine that I've established. And, I think country music is, as I understand, it's probably one of the most popular out there, and it's evolved, and there's a lot of music. I haven't gotten to it yet, but I'm sure I will.
Yeah, I'm kind of the same way. I like I like Johnny Cash, obviously, and some of the older Waylon Jennings stuff, but like in terms of, I just haven't found the time to kind of dig into it either. What was your first concert, your first live concert? What was your first show you ever went to?
The first live show I ever went to was in Jacksonville, Florida. It was July 4th, 1976, the bicentennial. And fortunately, I was in Florida, and I think if I got it right, the Marshall Tucker Band, Leonard Skinner, Charlie Daniels Band, and there was another Southern rock band, and it was just absolutely glorious. The unfortunate thing is we had too robust of a pregame. And I think I got to only see half the concert. I was there, but I think I only got to see half the concert.
It does happen. It does happen. Yeah, there's a lot of shows prior to I quit drinking about 5 years ago, and it's a lot of concerts I don't remember. Now I remember them all very vividly, but it's one of the benefits to quit drinking. So, but yeah, I had plenty of times where I went a little too hard and then just have very little recollection. But Skinner, man, seeing Skinner at that point in 76 must have been something else. That's for sure.
Unbelievable.
Yeah, that's amazing. So were any of your family members attorneys, or like what did your dad do? What did your mother do for a living? Or were you kind of like, were the kids in terms of your siblings, were you guys going to be kind of the first generation to get into higher education, or how did it go?
Yeah, neither of my parents went to college. I was in aunts and uncles, one of the first to go to college, but I was blessed. My paternal grandfather, and I won't get into the story, but my father's real father was a philosophy nut. He loved to read philosophy. He loved logic. And I call it sort of the generational skipping gene. And I used to go to his house every Sunday, and he used to give me philosophy books to read. He was big on being a well-rounded individual, math, science, law, athletics. He was basically, you had to do everything, and you had to do everything the very best you could. And so he was really my de facto mentor. And him, along with my father, knowing what he missed not going to college, I really had just a fabulous support system. But there were very few people in my family who went to college, but I had fantastic mentors, and most prominently, my paternal grandfather.
Yeah, and I'm going to take it by your surname that you're Italian. Yes.
Well, that's my father's surname, but his real father was John Patrick Larkin.
Really? So
My mother's 100% Italian, but my father he's half Italian, and the heavy gene is the Irish gene.
yeah, that's my same. My father was 100% Italian, and I'm also Irish Scottish. So I feel like do we just become best friends? I'm not sure, or not that just happened. But
I think genetically we have no choice.
yeah, yeah. So like I was thinking, because so my wife is Jewish, I'm Italian and Irish, and we have a very, very loud household. Because Italians tend to be loud in terms of just how we communicate with one another in our own homes. Do you have a loud house, or do you have a nice, peaceful, quiet home in terms of like, and I'm talking more when the kids were, school age?
So you're talking about when I grew up as a kid, or my family, our children?
Both.
Okay, so when I grew up, the men were fairly quiet. They were. My father was a notorious street fighter, and the apple didn't fall too far from the tree. But oddly enough, and it was basically like my father had a rule, and he said if I was going to box, I had to follow the rule. He said you had to give the other guy 2 opportunities to back away, right? And because we boxed, everybody would drink and then want to come challenge us to a fight. And so his rule was you ignore, and then you do something actively. You don't run away. And then he said the 3rd time you better throw the first punch and end it right away. That was his rule. But in the household, the men in the family were very quiet. Watch a sporting event, eat, go on the couch, go in the chair and fall asleep. The women in my family were so strong, so boisterous. I've often said my mother had the best right cross of anybody in the family, and everybody was a trained boxer. She had the best right cross. She let her hands fly more than any human being I've ever seen. But my mother, her mother, my great aunts would, around the holiday, they would tell stories of conflict, about arguments they got into, who was a bad person. And they would, as they told the story, and I used to go to the table and sit there in fascination with my mouth agape. They would be more angry telling the story, I think, than when the actual event occurred. So the loudness came from the women in my family who I think used conflict as oxygen.
God, it's like looking in the mirror. Yeah, because my grandmother, my maternal grandmother, my father's or paternal grandmother, she was the most powerful woman that I've ever met. She was my everything. She was absolutely heroic. She was the first woman to ever get into radiology school at DePaul University here in Chicago. Like, she was just unbelievable. But in my entire life, I probably remember my grandfather saying a total of 200 words. But my grandmother, she was never at a loss for words, and she was very, very passionate, and she could hold a very, very long, never-ending grudge against somebody that she'd felt had wronged her. So yeah, I can relate to a lot of what you're saying for certain. So as far as when you get into law school, did you go in because I think a lot of people, it's a bit of a misnomer. I think that people think that everybody who goes to law school wants to litigate, which couldn't be further from the truth. When you went into law school, when you decided to go to law school, did you know going in that you wanted to litigate?
Yes, I did. And I knew I wanted to be in the courtroom. I knew I wanted to be a trial attorney. I went to pharmacy school before law school, became a pharmacist, went directly to law school. But I knew when I went in, that's what I wanted to do. I wasn't certain, but I went in mindset that I wanted to be a litigator, and that was only solidified as I made my way through law school.
And how long did you stay in the pharmaceutical world?
Well, it was back then, it was a 5-year program. It's now a 6-year program. But I graduated, I sat for the boards, passed the boards, got my license, and then I went directly to law school. But I did work as a pharmacist during law school. I went to day law school, but I would work Sundays as a pharmacist. It was great money. And I used to go into the pharmacy. You couldn't have a pharmacy open in New York State without a pharmacist, but there weren't that many people coming to the pharmacy on a Sunday. I'd work 9 to 6. I'd bring my law books in my left hand, a TV to watch whatever sport event was on, do my job, do my homework, whatever. And then a check of some size would come in the mail. And it was like Pavlov's dog. I couldn't let go of that great gig. But I did practice, and I did it. Actually, I was practicing law for, I think, a year, and I was still working in the pharmacy in the Sunday. And my wife said to me, she said, "What the hell are you doing?" And I said, yeah. I said, "I've become a bit of an automaton on this," but I did a stint as a clinical pharmacist in a hospital, which was some of the most rewarding work I've ever done. Because, spoiler alert, the doctors have their lane and they know very well. But when it comes to what's the right medication for the right situation, there's nobody who shines brighter than a pharmacist. So it's a great profession, and I could have easily have stayed in pharmacy, but decided to go to law.
Like, what gave you the itch? Like, I mean, my father was a lawyer, and I didn't go right into law school. I was always kind of lurking. And I ended up a little later. I was 29 when I decided to go to law school. But like, what was operating in your mind that kind of pushed you towards getting into the law?
Yeah, what was operating in my mind, Bob, were a couple of things. One, my grandfather, who was big in philosophy and said, to be well-rounded, you have to do law and medicine. And so I had done the pharmacy, and I would go there every Sunday, and he said, "Okay, you're graduating now. You've got to go to law school." And I said, "Yeah, Grandpa, but there's the issue of money to go to law school." And as he looked at me so endearingly and with such great support, said, "You'll figure it out." And I did. But really, so that was it. As you mentioned, a great way to say is lurking. So it was sort of lurking in my mind. But also, I was the president of the Student Pharmaceutical Society of New York, and they had a lawyer who was absolutely mesmerizing to me in the way he comported himself. He was flamboyant, but not overly flamboyant, very articulate, appeared to be a very good critical thinker. And that was the first time I'd ever seen a lawyer in action. I said, "Gee, that looks really fascinating." So I was going on for my doctorate in pharmacy. I got accepted at the University of Cincinnati. And this was a crossroads. And I basically said, you know, I'd like to give law school a try, but I got this wonderful appointment. They're going to pay me $10,000 a year. Back then it was a lot of money as a stipend. And then, you know, I get my education. So I called them up and almost didn't call them up because I thought I would blow it. And I said, listen, would you consider keeping that position open for a year so I could try law school? And they said, yes. If they'd have said no, I would have basically just taken it and I would have never been a lawyer. But fortunately they did. And I'm forever grateful to the University of Cincinnati's pharmacy doctorate program for doing it. So there wasn't a lot of forethought. It wasn't like, oh, I'm going to combine this, I'm going to do this. It was just, I wanted to give it a shot for the intellectual and curiosity reasons.
Yeah, that's amazing. That's amazing. Yeah, I mean, you could see that your work ethic that was always instilled in you from such a young age just has always been a driving, motivating factor for you. That's amazing. So when you get out of law school, what's your first gig? Do you hang a shingle? Do you go work for somebody? What do you do?
No, I went and worked for a very good law firm. I've always had fabulous mentors, which is why I'm so big in mentoring. I worked for a judge, Judge Dominic Gabrielli, who just came off the New York State's highest court. This was at Nixon Hargrave, the law firm now Nixon Peabody. He was amazing. He was of counsel to the firm. I was assigned to him. And also I was assigned to Ed Burns, one of the very few, with all respect to Harvard Law School, one of the very few good trial lawyers to come out of Harvard. Most lawyers that come out of Harvard are not trial lawyers.
Right.
But he was, and he was fabulous. So I had both of them as mentors. And so it was just, it couldn't have, they had a structured program. It could not have been better for me when I came out of law school. A great firm and also just fabulous mentoring.
That's
so
amazing.
how much of your practice, obviously this was a Karen Reed case was criminal defense. How much of your practice has been criminal defense?
Yeah, I'm going to say a rough percentage, Allison, about 10%, 15%. And the vast majority of that is white collar, insider trading, SEC, Foreign Corruption Practices Act for your viewers, translated into companies, individuals alleged to be bribing officials in foreign countries to get work. So that, and then white collar in the energy and environmental field, people alleged to violate laws, environmental laws, dumping of hazardous waste, emitting pollutants in a alleged criminal matter. Those are the types of criminal cases. The Karen Reed case is a unicorn for me.
Okay.
Yeah. Yeah, because we were curious. We were talking about that in terms of, because I think in terms of litigation, litigation is litigation. I mean, you cut your teeth on being in a courtroom, learning how to direct exam, cross exam, which is really takes some honing to get proficient at. But in terms of your civil background going into the Karen Reed case, did you find that was exceptionally helpful in terms of kind of who you were geared towards handling in terms of witnesses? Because when you came on, it was pretty evident to me that you were going to be handling most of the science aspect and most of the technical stuff in terms of the experts. I mean, was the fact that you had been practicing civil for so long instrumental in kind of making that an easier transition for you going into that case?
The answer is yes. And Bob, to your point, I believe as a trial attorney, if you can try cases at a certain level, it really doesn't matter the subject matter. Right. I have had a variety of cases pretty much all my life, which requires me to learn, excuse me, a new area and really get up to speed. So this really didn't present, at least in my mind, at the risk of immodesty, anything overly daunting. And I was supposed to go in initially just to have a couple of experts, and that was going to be it. And then I was asked to do, as things went on, much, much more, and then much, much, much more. And as you saw, I was doing most of the motions arguments, and I was arguing most of, 2 mistrial motions, in that regard, which was even more than just expert. Excuse me. And so, but I will say this, on my team were, in my view, some of the best attorneys in the country. So it was easy for me to say, yeah, I'm going to do this and spend, a little bit of time and bounce things off of them, which was just a great asset. And then Karen Reed, who's just a brilliant person who knew the case, backwards and forward. But I didn't find it different. I practice and I try cases, and I'm in courtrooms all across the country. I have to learn different rules, different procedures, and this to me was just a little bit a different version. But I also had the safety net of fabulous criminal defense attorneys.
For all those motions that you argued, did you actually have to draft them as well, or did you dictate, or did you just have to argue?
No, I drafted. I like to draft most of my own papers. We had, but I don't want to make it seem like this was a sole effort. We had, as I'm sure you heard, law clerks, and there were students at Harvard and students at Boston College. Absolutely fabulously brilliant. I thought I was ahead of my time when I was in law school. These men and women were just off the charts good. And so they were doing research and writing memos. But when it came to the motions, with few exceptions, I was drafting it. If you just take a look at it, I have a fairly distinct writing style, and I think you can pretty easily tell when I was drafting a motion.
Yeah,
that's true. That's true.
We always wait, because that was one of the things, and one of the things that I wanted to talk about, which kind of dovetails into this concept that you never sleep. But in terms of drafting motions, and we're not talking about, just motions in limine where you're trying to argue a point or a motion to reconsider, her not allowing Michael Easter to come in and testify, but you're drafting major motions to dismiss based on prosecutorial misconduct in the middle of the trial. Can you talk about, like, in his attorneys, Allison and I understand just how difficult that is in terms of time management, because
shifting your mindset from preparing for one thing to like completely invested in researching and writing a whole different thing.
Yeah, because your witness prep doesn't stop, right? So how did you make the time to do that, and how difficult was that?
Yeah, you're absolutely on point. It is challenging, and to Allison's excellent point, you're sort of like you're in witness prep. You're doing your outlines, you're gathering your evidence, you're figuring out how to put it in, and boom, here comes this motion. You just have to use a different part of your brain. But to be clear, on the prosecutorial misconduct motion to dismiss, that was Liza Little. She's a fabulous writer. She does excellent work. She did that work because you mentioned one specifically, and that was her and AJ working on that, and with Karen. But for many other motions, particularly the Daubert motions, that is where I was doing a lot of the drafting, and that was the onslaught in the beginning, where the Commonwealth went after Dr. Russell, went after Rick Green, and then I returned serve going after their experts in drafting those motions, and then motions in limine. Liza did pretty much wrote the biggest oar on that one as well. But as certainly as things came up through the trial, but one of the big items was AJ asked me to defend him when his pro hoc vice was on the line 3 times, and unnecessarily so. AJ, worked to the highest ethical standards, and I called it the ARCA hoax. It was a hoax, but AJ asked me to defend him, and at one point it was very, very serious. Actually, it was serious at 2 points. I spent 8 days straight. I'm not kidding you. 8 days straight, getting up to speed on Massachusetts professional rule conduct 3.3a. I remember it like it was yesterday, and really defending that. So that was an example of something, popping up, and that kept popping up, that took a lot of time and a lot of effort, but it was worth it because of, obvious points. But in conclusion, yes, motions and all that in the middle of the trial just adds to what you have to do. But those are things you do to get the job done.
So
Indeed.
I don't know if you often practice in small towns, but we've practiced in Philadelphia, Chicago, and then also very small towns, and I find in those smaller towns, the judges treat the defense attorneys with a little less respect and challenge and question the integrity of a defense attorney sort of more often or openly. Um, do you find that in other smaller towns? And here, like, was that really hard to deal with?
The answer is absolutely. I travel across the country, and you do find it. Attorneys who do a lot of work in different states have different verbs for it. You get localized, you get hometowned. To me, it's part of what you're going to be up against, and I don't mind about it. It's just basically like that's the baseline, and I still got to get the job done. And I often say it's like a golfing handicap, right? It's like, okay, the other side's got a +10 handicap. I still got to win the tournament, find a way. But absolutely, Allison, I do find that happens. And, I don't attribute bad intentions to judges. I just think they get used to certain attorneys, certain ways they do things. And then there's just also the sort of geocentric aspect to it. And I've got story after story, which I won't get into on here, about just being at different places and just the wild thing judges will say and do to you. But you got to find a way to get it done. And apropos to this case, I heard many things about what I should expect coming on to this trial. So I put that in to the mix, but still went in with a mindset of I want to be viewed as a fresh start as myself, and so I'm going to go in and I'm going to give the judge and everybody else a fresh start perspective and go from there. So there were absolutely additional challenges for the point you made, but my job was to achieve the client's objective, and that's what I was focused on. And I will tell you that it made it interesting almost every single day.
Did it feel sort of, I don't want to say like a level of disrespect, but I just remember as an onlooker when it was early on in your arguments, and then the judge said, "Don't tell me what you're about to say, just say it." Was that like off-putting to the sense that it throws you off when you're trying to argue in front of a judge for her to say something like that? Did you take it
I
as
remember that.
disrespectful as I took it for you?
Yeah, I remember exactly what you were saying. She said, almost in a giggly way, "Okay, Mr. Alessi, you're going to tell me what you're going to tell me, and then tell me what you told me." And I just paused, and I looked, and I just said, "No." And then I just moved on. I probably was going to do that, but after she said that, I, of course, wasn't. But did I treat it as disrespect? I didn't. But what I did treat it as a challenge. I treated it as a challenge. It's like, okay, if the intention here, and I don't attribute ill motives to judges, but if the intention was to challenge me to maybe see how facile I could be after getting thrown off, I just took it as a challenge. It's like, okay, that's not what I'm going to do. I'm going to do something else. And you know what? My goal is to be 10 times better than what I was doing to try to be in light of your comment. And so that's the way I looked at it. I could certainly see how people would take it as a look of disrespect or trying to get me off my game. To me, I just go back, as I often do, to boxing. If you're going to hit me after the bell rang, if you're going to hit me with a low blow, if you're going to do anything else that maybe isn't Queensberry rule-ish, then I'm just going to figure out a way to come back harder.
Was it hard? You never showed on your face, but was it hard when, especially like the Daubert motions, the judge had, said certain things going into it, and then you make your Daubert motions and you meticulously outline the law to what, well, we're reviewing, it seems very black and white, like this can't be ruled against. They're not allowed to present, this type of expert can't present this type of opinion. You can't rely on an interview of a witness that has nothing to do with the science that you're looking at. It almost went directly against what even you would think just organically without even researching it. Was it hard when rulings would come down against you in the face of something that seemed so black and white and contrary to the law as the judge had sort of outlined it with regard to defense experts?
The answer to your question is yes. And this is why I love being on your show, because you're asking questions that only experienced defense attorneys who do trial work could understand, let alone ask the question. Yeah, I mean, I don't like to lose. And when I think I present winning arguments and I spend a lot of time researching and I think I make a cogent argument and then I get a decision that I don't believe reflects the law, doesn't reflect the facts, it is a bit unsettling at first. But I will tell you, I'm of two mindsets when I don't get an expert knocked out. And this was particularly going to be the case with their dog expert that never came on board. I basically feel like I'm heads, I win, and tails, they lose. If I knock out an expert, then okay, obviously I've won for my client. If I don't win the Daubert motion, that means I get to cross that expert. And that there's nothing I like more than to cross experts. So to me, it's kind of a win-win. But for my client, it's always best to try to knock out junk science experts when I can. But I will tell you, in the end, I was no less motivated, no less enthused by a decision. I've won decisions in Daubert motions that I probably should not have won. So in the end, I think it all comes out in the wash. But when you get an L, no matter how small the L, it's still an L, and it doesn't feel good.
Right.
Especially if you're right on the law, because I mean, as a baseline, my expectation of any judge that's on the bench is that they follow the law, no matter which way it leads them, and kind of when you're thinking about your civil practice and the judges that you practice in front of, and Allison and I have done our fair share of civil cases. The bulk of our practice was criminal. So we're in front of criminal judges that are in the felony division far more often. And kind of to a judge, there seems to be a much greater disdain towards defense attorneys in general in the criminal courts that you just don't see in the civil courts, because they just don't view the litigants the same way, I think, in terms of civil litigation. I mean, did you find that to be true? And I know you were forewarned coming into Judge Cannoni's court, but were you taken aback a little bit by just how accurate they were in their estimation of what you could expect in terms of kind of how she was running this trial?
Or challenging the integrity of the lawyers?
Yeah, those are two excellent points with two different answers. So I'll take Bob's first. The answer is what I encountered met my expectations, and it met what I was expecting. So I was prepared for it, and I acted accordingly. On the topic of challenging the integrity of the lawyers, I was incredibly insulted, and I don't get mad very often at all, but inside of me, I was seething. There was no basis whatsoever to do that. Do attorneys make mistakes? Do they put things in papers that are inaccurate? Absolutely. The question is, what happens after they do that? Do they own up to it? Do they correct it? And the defense in the second trial had made a mistake with regard to an ARCA invoice about whether it had been paid or not. And we actually had a draft that probably should have been reviewed a little bit better. And we all take responsibility for that, including myself. But within, days it was corrected. And that was the only instance of which I'm aware that the defense team had made a a inaccurate statement. And the rule is it has to be knowing to have a violation. And so there was nothing knowing about it. It was a mistake. And what was particularly disquieting to me, and I'll never forget it, and I'll never forget the dates, on February 11th, when the grave concerns came up, when Attorney Brennan went through and claimed he had to go get all these documents from the feds, when in fact we gave him the documents. And when I went back in on February 18th after the grave concern comment, and I went through chapter and verse, I spent almost the entire week preparing for this, and I pointed out 10 misrepresentations of the Commonwealth, 10 compared to the 1 or 2 that were highlighted, and wrongly so.
Not to mention the inverted video offered in front of her jury in her courtroom, but
excellent point, which is the worst because it's in front of a jury, right, and not instead of front of a judge. And I was hoping that there would be some mention by the judge, especially after the grave concern, and that's why we were there. And I went through and just page by page, document by document, showed that there were no misrepresentations made by any defense attorney, and pointed out the 10 by the Commonwealth, and not a comment, not a question, a comment. But you know what? I said to myself, not a hint, nothing, not even a comment,
no,
let alone a hint of concern. But you know, I just, again, I look at that as I got to find a way still to go. But yes, I was particularly unsettled in this sense, almost angry over it, because Ellen Jackson and David Yannetti and Liza Little are just some of the most ethical outside. They're aggressive, and that's why they're successful. But I underscore that even though there were these allegations and rulings, not once, and I listened very, very carefully, not once was there a fact stated as to what the supposed ethical violation was. Not one fact. It was just, I find a violation and I found it was intentional. But listen, I can understand when a judge believes he or she is not getting it straight up. They understandably have the right to be plussed. To me, the predicate that there was a misstatement, to me, just didn't exist, which made it all the more disquieting to go through that process.
yeah,
And I can tell you from our side of it, watching, you know, covering this trial, that we were living vicariously through you, and all the attorneys at that defense table. You know, we've experienced very similar situations with judges, and in particular when it came down to the attack on AJ, with respect to her finding that he lacked candor to the court. We were so furious, and I mean your sense of anger, as much as you may have tried to mask it in that courtroom, still came through in a very calm type of way. I could see that you were furious and you were fuming inside, because the bottom line is all of that was a non-starter. It didn't matter. Like Hank Brennan trying to turn something that was nothing into something was outrageous. And the fact that she just refused to acknowledge it when you laid it out so beautifully, like you said, you prepped for that thing for 8 days, you know, and when you laid it out, because look, the bottom line about Wolfe and Rensselaer is these guys had prepared these reports at the behest of the Department of Justice, unbeknownst to either the defense or the Commonwealth. So what they said,
words,
what they found is what they said and what they found, and no
independent.
Right, they were completely independent. So whatever they may have gotten paid after the fact, whether it was traveling to the, you know, to the trial and testifying, and you know, you get to pay for their food and their board and their travel and all that stuff, whatever that case may be, you know, the way that he was trying to frame it as if this was some kind of nefarious act. I mean, we you know, and it was like the whole signal thing with him. just trying to make signal into something that's some kind of nefarious, shady thing for a lawyer to be communicating via signal. I mean, it was really, really hard to watch as attorneys. And I'm just so grateful that we had such competent, outstanding defense attorneys in that room to do what you guys did, because you guys, and I'd be remiss, I forgot to congratulate you initially for an amazing job in that trial. All of you, that whole team was outstanding. It was such a boon to the defense bar in general. When I emailed you, I went through a long diatribe, but I meant every word of it in terms of, we've been trying to push the needle on this channel, trying to educate people what it is that defense attorneys really do. And it kind of goes into what Allison was introing in the very beginning. It was like that case, which took on this life of its own and became really the case of the century. I don't think there's any argument about that at this point. And what you guys were able to do with the world's eyes upon you was so impressive and so important. So I applaud you for amazing work there. I'm sorry I didn't say that in the beginning, because I meant to. I was too starstruck with you. I told you I had this whole fanboy thing with you. But no, I just wanted to articulate that because you guys did amazing work there.
And I know you guys have been big about not wanting to toot your own horn, but I'll just say defense attorneys in general, I've always said, are the unsung heroes, defenders of the Constitution. I'd love it if you could explain to our audience why defense attorneys are so critical to maintaining the checks and balances of the justice system, and how you saw that play out in the Karen Read case.
Yeah, it's a very important point. I'll start with the point that each of you have made is defense attorneys, in my view, play one of the, and particularly in criminal cases, play some of the most important roles of attorneys in our country. I have great respect for government, but our constitutional founding fathers, who were brilliant, prescient people, all understood that government often gets out of hand. It's too powerful, it's too big, it's too unchecked. Even with our wonderful checks and balances system, they don't always work, and oftentimes they don't. And you can look at it as Russian roulette, or you can look at it whatever analogy or metaphor you want to have. But it's either going to hit you, it's going to hit your family member, it's going to hit your friend. Government is going to land on your doorstep in the wrong way at some point in your life. And you need a defense attorney that is skilled, that's passionate, that's committed, that is going to fight hard for you. And that's just your ticket in to have a chance. And so anybody who's gone through the system unjustly or even justly knows the value of a defense attorney. The Karen Read case really heightened my own respect for the defense bar, because this type of what I call the more blue collar criminal defense, I had not done much of at all. So I will tell you for the audience that I don't believe there's any more important lawyer in the country than a defense lawyer for a blue collar criminal situation. You can look at the statistics. You can look at how many people are wrongly accused. You can look at how many people are overcharged. You can look at how many people in government law enforcement either inadvertently or advertently have bias, and they just go after people. And the only persons standing between an unjustly accused or an overly charged accused is a defense attorney. And my last point is this. I believe there is a way for a defense attorney to comport themselves, how they behave in a courtroom, outside a courtroom, where you can be aggressive, but yet you still can do it in a way where you show manners, you show respect to everybody around you, but you can still be aggressive. And the only thing I would say, without getting into sort of proselytizing this topic, is that I always encourage defense attorneys to be aggressive, but to do so in a way that is respectful enough to get the job done. But to do it that way, and I think defense attorneys today, and particularly in 2025, I think their value is finally starting to get recognized for the due, because we just see more and more, unfortunately, the government overreach, and people now, particularly with social media and with folks like you who are able to put on social media and go through a trial moment by moment and educate and say, okay, listen, I'm at the top of my game. I do this, and let me tell you what's going on here. And I think that's just another added benefit. So I think the function that Bob and Allison, you perform, I think incredibly increases the value in society's eyes of defense attorneys. But at the risk of repetition, I don't believe and I do high level corporate, it's a white shoe firm, but having gone through this Karen Reed trial, I just don't think there's any more valuable attorney in society than a criminal defense attorney.
Well said. Well said. And the verdict in Karen Reed's case renewed so many people's faith in the justice system. But I have to admit that in one breath, my faith was renewed. But before I could exhale that breath, my thoughts turned to how a defense like this is just not available to almost anyone else caught in the system. Do you think Karen's acquittal is proof that the system worked? Or is it proof of how badly it's stacked against the average defendant who can't get this kind of defense?
Yeah, I think it's a little of both, but unfortunately, I think it's more to your point that it took the defense team that was put together, that rarely gets put together like that. It took all of us and everything, and we got it across the finish line. But that was not a guarantee.
Right.
And I think it just underscores your point, which is there's still too much power and unchecked power in government when it comes to investigations, when it comes to grand juries, when it comes to what gets charged. And then what's happening today more and more, and I'm an optimist, I believe the pendulum is swinging in the favor of what's right. But prosecutors today are not the same prosecutors of 10 years ago, 20 years ago, when they would just look to do justice. And they, I've had cases where prosecutors would turn over materials early in the case that were helpful. They would withdraw counts when they saw that they weren't valid. I don't see that happening much today. It's too much of a competition to win. And was there ever a case where it was more of an elucidated example of win at all costs rather than search the truth than the Karen Reed case?
Oh, no. And that the Karen Reed case exposed serious police and prosecutorial abuses and misconduct. For a lot of people watching, it was jaw-dropping. But for lawyers who do this work, it feels more like an extreme and more blatant version of things we see all the time. If I'm being honest, some version of that is happening in police departments and courtrooms across the country. In your opinion and experience in covering, I don't know if it's any different when you're dealing with white collar crimes or which courtroom you're in, but in your experience, how routine is it to encounter some level of police or prosecutorial misconduct? Is this the exception or more feature of the system that people don't want to admit?
Yeah, I have the majority of my practice in federal courts. I'm going to say it's probably 70% federal courts, 30% state courts. But since I do a lot, the 30%'s a lot. I find with, for example, assistant U.S. attorneys in the federal government, they're generally, with a few exceptions, unfortunately,
Yep.
they're generally doing what I would expect a prosecutor to do. It's
Yes.
just when you get to these counties, and you pick it in any location in the country, there's just all those interpersonal dynamics, who went to high school with who, who's getting elected, whose mother and father work together. It just gets to government's best close to the people. But when it comes to law enforcement, I always say sometimes it's not good to be that close. And so to me, I find it even now creeping in at the federal level, particularly not this past year, but the past, 4 years. I saw it come in at the federal level, just activists in the FBI, activists in U.S. attorneys' offices. And I'm hopeful that that changes. But to me, that adds an extra layer. It's one thing, and certainly district attorneys and U.S. attorneys are part of law enforcement, but I always sort of looked at a bright line between the law enforcement being a police officer and FBI agent on the one hand versus the district attorney, assistant district attorney, or the U.S. attorney on the other. I believe it's the job of the U.S. attorney, these district, to bridle their own law enforcement, to basically be the first check and look at a file and say, you know what, you guys didn't do this right. I'm withdrawing this charge. So that it serves as a deterrent to law enforcement. But when you don't do that, law enforcement feels they've got license. And then in certain instances, when the assistant district attorneys become part of the process of violating the rights, either inadvertently or inadvertently, then that's when it reaches the danger point. And we're there in too many instances. And again, to the point, that's why defense attorneys are so valuable and so important.
Yeah, and it's one of those things where, to your point, in terms of the prosecutors kind of being the gatekeeper of, if they look through and they're like, all right, this search looks like it was bad, and I'm not going to drag this thing into litigation because obviously a competent defense attorney is going to come in and they're going to file a motion to suppress or quash, whatever the case may be. And you don't see that, and then it's left to us where you have this prosecutor who's aware that the search is bad, yet they're going to come into the court after they didn't gatekeep it. They didn't say, you know what, we're going to kick these charges. Let's go on to the next case, wherein you would hope that that would be a deterrent to law enforcement, that the cops that are their arms of law enforcement, because I don't know that people understand that prosecutors, we defend cases in several counter counties or collar counties out of Chicago, and these prosecutors in these offices, like for the counties, probably have 10 to 15 different police departments that are at their disposal depending on the type of case, and they do their bidding. Like if they're like, I need more evidence, I understand you made this arrest, but this is what I need, and they go out and they do what they need to do. But to go back to the broader point, like you've got that prosecutor who lets it slide through, and then we go in and we file the motion to suppress, and you've got a stateside judge, and the thing gets denied, even though it should have been granted. And it's just like, it goes to Allison's question, like where do we make the changes? How can we incorporate? I don't know if it's legislature. I don't know if it's statutory. I just don't know how to make inroads into solving this problem, because it's just, and it's not getting any better. I mean, Allie and I have been doing this for 20 plus years, trying it, and nothing has changed. Nothing has gone into, taking a different path, unless we get a prosecutor that's elected on a different type of ticket, in terms of saying, look, I'm coming in, I'm going to focus on mental health issues and addiction. I'm going to realize that those usually play a major part in terms of why people are committing crimes. And I'm going to acknowledge that in the offers that I make and things of that nature. So short of like a prosecutor, getting a good prosecutor in there that's going to do the right thing, like what other remedy is there?
I've spoken on this before. It's a good question. I don't purport to have all the answers. I think there should be state legislation that should require prosecutors to, as part of their continuing legal education, to take mandatory courses on topics such as how to better interact with law enforcement to make sure that proper processes are being followed. I believe that they should be required to attend ethics training and have role playing and specific examples of when cases and counts should be dropped. I think law enforcement should be required to take similar courses. I think there should be more judges willing to knock cases out where they can see clear prosecutorial or law enforcement misconduct, because I think that would also be a deterrent. And lastly, I believe what should happen in this whole area is that law schools from the jump should be training their attorneys more on ethics, more on situational experiences. I mean, think back when we were in law school. You had like one course on ethics, maybe two that you took, and that was it. And it was so abstract that it was like you just memorized the code and you didn't have real world experiences. But I believe it should be mandatory in law school, where they should have essentially a clinical course where there's a stop, look, and listen about your ethical conduct. So I think bottom line, legislation and education that forces people to have to face what is going on. And lastly, and most importantly, is I believe people should become more involved in government and more involved in races for district attorneys to make sure you get the right people in. Because I think the only way in the end you're going to ameliorate this problem is to get elected district attorneys that are forced to go in on a platform where the things we're talking about actually are put into practice.
Right.
Well, and with the ease by which people now record and post interactions with police, social media has made it impossible to ignore police abuse. And more people following trials, seeing misconduct from prosecutors too. It feels like there's momentum now for criminal justice for reform, for the people to push their representatives to focus on that. And a lot of what you just said would be great aspects of criminal justice reform. One idea I've floated, and I'd love your thoughts as far as like overcharging and prosecutorial misconduct, police misconduct, but is having a member of the defense bar and a prosecutor involved in charging decisions, or members of the defense bars as part of also as part of an oversight committee. Do you think something like that could work?
I think it would work. I don't know if we're ever going to get to the point where a defense counsel is going to be part of a charging decision. But what I would like to see is analogous to what happens with privilege reviews when you have, like, there's a privilege issue and somebody else in the district attorney's office, a retired judge or someone, it's referred out to them to look at the material to determine what's privileged and what's not. And I believe not every case should have that, but I believe if the defense counsel can make a colorable claim that the case has been overcharged, I would like to see legislation to the effect that it then goes to a retired judge, it goes to someone just like a privilege review, and there's a recommendation made as to what should happen. And so that's my proposal to sort of get it away from where it is right now. Even my proposal, I don't think has a lot of legs in the near future, but I think if enough people push for it, something has to break from the current system of going to a grand jury. We all know the ham sandwich analogy. We've got to find another way to go about doing this. And there just has to be more checks and balances put into that system. Those are my ideas.
I mean, and those are some great ones, and it tails right into actually two of the questions that I had for you. But one of them at first was dealing with the fact that, like, generally speaking, the exclusionary rule addresses police misconduct in the sense of excluding evidence illegally obtained. That wasn't really applicable in Karen's case. That the misconduct and abuse of power we saw in Karen's case is not the type the law really has a remedy for. or the available remedies like dismissal are not applied to address misconduct not tied to the admissibility of evidence. So I was going to ask you, if you had to appeal this case, or you were writing to a judge about, we need changes in the law, what might be requested to remedy pretrial misconduct like what we saw in the Karen Reed investigation? Or do you think we could come up with a new basis for interlocutory review by a higher court when police and prosecutorial misconduct is a real issue in the case? Like you just said, when there's a colorable claim, and maybe what you just proposed could be a step one to that there be some sort of external review by a retired judge or the attorney general's office or something like that. But if you had to appeal this issue, for those of you who don't know, like, if the law's not on your favor, you can move the court to change the law. Well, is there a change in the law that you might seek for something like this when they can make a colorable claim of the type of abuse and misconduct we saw, in this case?
Yeah, I do have a specific thought on that, and it is this. I believe one of the most exasperating aspects of certain trials, and the Reed trial was an example, is not getting evidentiary hearings. And in the Reed case, I thought the defense well crossed the threshold on the motion to dismiss.
Yep.
For at least an evidentiary hearing. There were other instances, Daubert hearings, where I thought at a minimum we should have gotten an evidentiary hearing. I would like to see there be clear guidelines for when an evidentiary hearing is warranted. I think once you get to an evidentiary hearing, you exponentially increase your chances for having a better platform to expose these types of malfeasance that occurs in the process. I found that the level of discretion in Massachusetts for the trial judges to deny evidentiary hearings was a very big issue that needs big attention.
So that could be one of the changes in law that you could have requested if you had to appeal, and that would definitely, if there's not like a clear guideline for that, and it's so that there's that much discretion, because I agreed. I remember screaming at the TV, like, why isn't there an evidentiary hearing? Why is Brennan up there just telling the judge, oh, the cameras in that Sally Port were just defunct. They had been doing that for a really long time. Here's an occasion it happened before with no proof, no evidence, nobody swearing to it. Bob and I kept screaming, "What? I am not going to believe anything that they say unless they have something that was tendered to another lawyer, presented in a court of law before that date. If this was an issue, then prove that it was, that actually occurred, and that you just didn't invert a different video." And we were shocked that she was ruling on something like that with him just saying things without an evidentiary hearing. And I can't imagine how frustrating that was on your end.
Yeah, it was frustrating. Again, I think anytime cross-examination can occur, which to me is the greatest technique to get truth out, we're all ahead of the game. Everybody should be invested in getting the truth out, and cross-examination's the best way to do it. And an evidentiary hearing is a way to cross-examine witnesses, and particularly on the topics that we're talking about. So that is why I perseverate on evidentiary hearings, because I think that is the best way to augment the points that are made in motions and really put in stark relief exactly what's going on. I got a few of those. I got a voir dire of Welcher, and it was, quite beneficial to get that. And that was what I call a sort of a pseudo evidentiary hearing. And then I got the speed dating version of examining Dr. Wolfe and Dr. Rentschler to show the hoax. But the more I was elucidating the hoax, the shorter my time was that I was given to do so. But those are just 2-3 examples of how in the middle of a trial, when you can have a voir dire or an evidentiary hearing, how helpful it is to getting at a lot of the topics we're talking about here.
Yeah.
And
no,
I
for sure.
thought that it was such a boon when Hank Brennan had the same opportunity with both Wolfe and Rentschler. And what he elected to do, instead of addressing maybe some of the actual issues that would have been an issue at trial, namely the science, he elected to spend all of his time harassing Wolfe about this bullshit about the paid monies, and like just trying to create this fire where there was no smoke. To me, that was huge. That was such a massive mistake by Brennan to waste that opportunity that he had to do exactly what you were talking about. And he spent all his time just trying to hammer home this point. And to the extent where, I mean, Alice and I, to a person, were of the absolute mindset that there's no way she's going to keep them out, which we knew that she couldn't. I mean, you have to allow Karen Reed to have a defense. There was going to be no way that she was going to keep them out. She may bar them about saying certain things. She may give Hank a long leash, which she did. I mean, I pretty much predicted exactly what she was going to do in terms of the way she did it. And that was based on watching her over 2 trials, because she became very predictable in terms of how she was going to address certain things. But in terms of the adverse rulings that you guys got as a team, and there were many, which one going into the trial, and I'm talking more with the motions in limine, which one were you most concerned about? I'm curious. I had one that I was primarily concerned about, but what was the one that you're like, oh, this one hurts, like which one was it early on?
What are you're talking about decisions that came down, or the threat of how a decision could come down?
I'm talking about the decisions that ended up coming down with regards specifically to witnesses that she was going to allow in to testify.
No, I thought you were asking about the threat, the concern before it came down. I don't know.
Well, and I was talking about her actual rulings. I mean, the threat existed, but then she acted on it. So in terms of, you know what I'm saying? Like, there's one particular witness that I thought potentially was going to be devastating to not allow this particular witness to come on. And I want to see if you come up with the same witness, if you were concerned about this witness being barred from testifying at all.
Well, I can tell you ARCA was the one I was most concerned with. As you may recall, we were not allowed to mention ARCA at all in the opening statement because of the hoax. And that was key. I mean, this case, my coming on to this retrial, I was all about there was no collision, and I was propounding that theme in jury selection.
Yep.
And that was what I was adamant about in terms of the defense. And so there was no collision, stated 3 times. And then the experts that are going to support that, you can't mention in your opening statement. And then the continuation of that sword of Damocles being held over our heads throughout the whole trial. Bob Alessi, I was seriously concerned that she was not going to let ARCA testify. I should have talked to you a little bit more to try to get a little more comfort. You seemed that they were always going to be able to testify. I was concerned that they wouldn't be able to testify. But the decision that I was, I think the most, I wouldn't say disheartened, but it's close to that, was Michael Easter on investigations and how proper investigations should go, when she ruled he couldn't testify. And I don't want to relitigate that, But let's just accept that part of the decision. Then you have the Commonwealth put on Yuri Buchanan, who goes through days and days of how this was a proper investigation, and the judge basically saying in a ruling, well, a jury can decide what's a proper investigation or what's not. But then all these law enforcement are coming on in chapter and verse going on, like Gallagher, how complicated it was with the bad weather and why you would use a snow blower and why we had to use solar cups. And, this is what you do. It was
even that they
complicated.
didn't need to interview certain witnesses, why there was no reason to separate them. He even said things like that.
That's correct. Even the separation of witnesses, this is proper technique. We thought 100% that they opened the door to that.
Yes.
And I mean, blew the door open, and we thought, therefore, and we made the motion again to renew it to have Easter, and it was denied. That, not just initially not being allowed to have them, but then after the prosecution, after having tied our hands on that issue, just started beating with, Buchanan and Gallagher, the door being open, and then the decision, no, you're not. But listen, we as lawyers get decisions from judges. There's always got to be a winner. There's always got to be a loser. You still have to find a way to win, no matter what the decision is.
Yeah. And, that brings me to, and then I want to circle back to another question I wanted to ask you, but with ARCA, it felt to me like the judge's true motivation for not saying that they were hired by the Department of Justice was to not create, have the jury have what she considered undue credibility, too much credibility if they knew this. I mean, that's what it seemed like the only real motivating factor was. But I ask you, logically and legally, how is that any different than what the prosecution puts up? People that work at the FBI lab, people that work at the state police lab, and they go through all of their accomplishments and their background in police, any sort of law enforcement, when they're going through their background, their accomplishments, you worked for the president, you did this. How logically and legally is that any different than telling the jury the truth that these people were hired by the Department of Justice?
Yeah, listen, I'm with you, and I wish we could have fitted you for a robe for the Karen Reed trial on that topic, but we couldn't. The judge was clear on that in trial one that I was not on. I saw no indication she was going to change, and did not in trial two. But I will say this, apropos to the topic we just had. I believe the Commonwealth opened the door on that very broadly by the questions of Attorney Brennan of ARCA about, like, saying, all of this sort of relationship with the defense, and you're not independent, you're not. But that was all about what happened after the defense hired ARCA. But there was all that time we all know about, everyone except the jury, that to Bob's point earlier, in February of 2024, the ARCA issued a report, and then in March, that report was provided amidst 3,300 other documents that took a while for the defense to find. But all of that done before anybody knew the existence. So why, at least for that time period, right, for when they had their report prepared, why not just say who they were working for? But then again, the Commonwealth took advantage of our hands were tied and then started asking questions on cross of it, and called used the term your employer, which, was, I thought, quite egregious, and opened up the door for us to be able to say, well, let's talk about then who the employer really was.
Right.
In the end, again, it was just another one of those things that we had to find a way to work around it. And fortunately, because Doctors Wolfe and Rentschler were just so overwhelmingly competent and persuasive. In the end, I think the substance of their testimony prevailed in the second trial, but frustrating nonetheless.
But that was sort of Brennan's MO, and now I didn't circle back to the other question because now I just want to touch on this as far as just like saying things and that aren't true without any basis in fact. I mean, he did that with he did that like often. One example that you guys talked about on Attorney Melanie Little's show is how he asked Dr. Russell if she had any memory problems. I mean, when you take things like that and asking questions, and I can't remember them now. I was trying to look back at my notes and think about it, but so many questions he asked of witnesses that appeared to have no basis in fact, like no reason for the question. Is that prosecutorial misconduct or gamesmanship?
I don't believe it's prosecutorial misconduct. If I'm a prosecutor, that's not the way I'm practicing law. I just think there's a different way, as we know, defense attorneys defend cases and prosecutors prosecute cases. I will tell you the paradigmatic example of the topic you raised, Allison. It was the hoodie in the holes of the back of the hoodie. In the motion I made for a mistrial, the second time I made a motion for mistrial, that was very, very disquieting. And it was disquieting for two reasons. Let's assume that Attorney Brennan, not having been on the first trial, didn't know that the criminalist Maureen Hartnett, who I also cross-examined, let's assume he didn't know that she was the source of those holes. There were two other assistant district attorneys at that table that not only knew it, but I knew from my review of preparing for the cross-examination of Maureen Hartnett that one of those prosecutors at the table led her through her direct examination. You can go back after the show and look at the transcript. Went through how Maureen Hartnett cut the back of the hoodie and made holes and took sampling. That testimony was elicited in the first trial by an attorney that was sitting at that table for the prosecution. And at no point did I see evidence that maybe it just happened too quickly for the attorneys to send a note over. But at no time was it mentioned like, hey, let's take a time out here and have a caucus. And listen, mistakes happen in trials, right? Especially you go 2 months. We all make mistakes, but it's what we do with the mistakes that mattered. And I would say, Allison, the hoodie sweatshirt for me was quite disquieting.
Right, and I was going to get to those bigger examples as well, because you also had, so for example, Brennan raised the dog DNA in his cross of Russell, even though the Commonwealth didn't bring it up, and you vehemently, in their case in chief, they didn't introduce any evidence, and you vehemently argued a motion for a mistrial on that. But Brennan argued he intended to introduce the evidence in the Commonwealth's rebuttal case. He also tried to keep out John O'Keefe's x-rays, which to me, that is another huge example, the x-rays, of how not that prosecutor nor any of the other prosecutors sitting there corrected someone when their expert said, we have no x-rays of the arm, so we don't know. There very well could have been some fractures to the arm. And Brennan also argued to keep those x-rays out until the Commonwealth could introduce them during their rebuttal, a rebuttal that never came. Do you think like that was intentional? And and do you think that those actions, in addition to what you just said about the holes in the back of the sweater, that those actions together would warrant serious consideration of his conduct if it was to be reviewed by the Massachusetts Board of Bar Overseers?
Yeah, the unfortunate answer to your question is I don't know what was in Attorney Brennan's head. I don't know what he knew, what he didn't know. I don't know what was intentional, what was not. I can say, apropos to our prior topic, that Judge Cannoni did act on what she thought was in people's heads with the ARCA hoax. And so I thought she was well positioned to be able to come to the result that I was arguing for with regard to the hoodie sweatshirt. It didn't happen. I just don't know exactly what Attorney Brennan knew and what he didn't know. All I can tell is the frequency of those types of events were too high, in my judgment, for a prosecutor to make in one trial.
Yeah, I mean, where were her grave concerns? You know, I mean, that was the thing that we just kept screaming. I'm like, she's not going to even admonish Brennan at all for this behavior. I mean, because it was just one thing after another, and it was like I always was heartened by the fact of the way that you guys elected to try this case the second time, because I was of the mindset throughout the first trial, I was overly concerned with just the third party culprit approach, just because I know how hard it is to convince 12 people on a jury that this is the thing that happened. And I think you're kind of creating this de facto burden on yourself as the defense with that argument and trying to put that defense forward. So I was so happy the way that you guys tried this case, because the science was always going to win this case, because it's exactly what you said at the very beginning. John O'Keefe wasn't struck by a motor vehicle. That's the beginning and the end of the entire equation. And as long as you had those two guys that anchored your defense in terms of Wolfe and Rensselaer to get on the stand, and we all knew what they were coming in based on our ability to see how they testified the first time, and now they had the opportunity to do additional testing. You knew they were going to come in guns blazing. I was just so happy that you guys went the route that you did. And my question was, how much of your involvement in the case impacted the way that the case was tried? And I know it's a kind of an inner sanctum strategic question, but if you can answer it, I'd love to know. I'd love to know, because I know there had to have been debates ad nauseum about how you try this case with a bunch of brilliant minds sitting in the room, and you go back and forth on things, and that's just how it's always done. But did you have an impact in terms of at the end of the day, like, look, like, I'll die on this hill, I think we just need to streamline this thing and just focus on the science? Or was that a collaborative agreement at the end of the day?
Well, you mentioned it's an inner sanctum question, so I have to be circumspect about my answer to a certain degree, not for any ethical, because it's not, confidential information. It's just sort of for team dynamics, if you will. What I will say is this. I'll start from the end, which is we all saw a different approach to the second trial. It was based on science. It was based on what I call two things can't be true. So a third-party culprit, you can always have two things can be true. And I think, when you saw the jury in the first trial, allegedly, because I don't know for certain, it was sort of split on one of the manslaughters, which was disconcerting. And so to me, that was evidence that certain jurors in the first trial thought a certain way about this whole whodunit. And my firm view for trial 2 was, let's focus on, just as you said, the science, because if you do science right and you do the cross-examination particularly a certain way, then you can show that to the jury that really only one thing can be true. And if only one thing is true, then they don't have to get into the entanglement of the whodunit. And that is the approach that was taken at the trial. I will say this, I was delighted that was the approach taken. I was delighted that I was able to row the largest oar with cross-examining the experts on the Commonwealth. I was even more delighted that the Commonwealth made the strategic decision to put their experts up early in the case. I really was pleasantly surprised that they did that. So I got to go at Ian Whiffen, Jessica Hyde, Maureen Hartnett, boom, right off the bat. And also, I will say, and I tip my hat to her, Dr. Scorty Bello, bless her for being a witness who was straight down the middle, answered things. I was able to, if you compare the cross-examination of Dr. Scorty Bello in trial 1 to trial 2, I think you will see a contrast and walking her through the many things, including getting her to agree that the injuries to John O'Keefe were not evidence of being struck by a motor vehicle. That was something that did not occur in trial one. And so I, in answer to your question, I thought the defense team just worked well throughout the trial, and I just don't recall any matter that was not professionally discussed and a decision made in almost all instances with which everyone was comfortable.
And, you know, throughout even the prosecution's case in chief, the defense had so many huge moments and raised doubt as to each witness and each fact and each piece of evidence that on its face could have appeared inculpatory was shown to be exculpatory in one way or another. But from the start of the defense's case in chief, I just immediately felt like the jury was being given numerous avenues of doubt and all dealing with did the car hit the body? Was the car where they said it was when they thought it was? Was the body where they're saying it was when they say it was? But so many different pieces that every juror could connect with or latch on to something different and still find reasonable doubt. Now, was that, and I know you guys used the index cards at the end, and so I'm assuming all of that was a strategic choice because, you know, so many legal commenters say the defense has to pick like one theory of what happened and not throw out, you know, multiple different possibilities. Even when the evidence shows different possibilities, I've always felt contrary to that. But was the fact that we can give someone who's thinking this way can take this piece and find out, while someone who's looking at it differently can take this piece and find out. Was that part of the strategy, that there are all these different avenues that show different methods of getting to reasonable doubt?
Absolutely. I think one can compare the closing argument in trial one to the closing argument in trial two, and reasonable doubt was not a frequent flyer in the closing statement of trial one. And I don't Monday morning quarterback different dynamics. I wasn't there. But I will tell you, everybody on the team was adamant from the jump that reasonable doubt was going to be a term that was going to be overused, not underused, and particularly in the closing statement. And Allison, to your point, the whole trial was about having an eye on the closing statement. Every cross-examination was that, and you may recall, for Ian Whiffen, who, you know, him and Jessica Hyde knocked out a lot of teeth on the defense in trial one. And that was to the extent people could understand what they were saying, which I'm not so sure that was always the case. So my goal was to make it more understandable, but also, as I call it, shake hands with the prosecution witness, get them to become my witness. And I'll never forget with Ian Whiffen, you know, I got him to concede that the phone, he didn't show it on his direct, but there were, his own report that they didn't put in had circles where the phone was in the house. And for him to admit that was good. But in terms of the 227 House Long to Die, you may recall I got Ian Whiffen to say, I said to him in terms of the deletion of it, and I said, do you have, because he essentially concluded on direct that there was sort of some artifact as how it was deleted. And I basically said to him, do you have doubt as to how that was actually deleted? He said, yeah. And I said, and is your doubt reasonable? And that was the first seeding of the reasonable doubt, and it never stopped after that. But you're absolutely correct, Allison. Those index, that closing statement was purposefully done, and it was really the capstone, the culmination of everything we did. was with reasonable doubt in mind, so that those index cards could keep flying up. You didn't get to see it live from the trial, but every point in the closing argument had a little reasonable doubt index card that got thrown up. And by the time AJ was done with the closing argument, it was like somebody had just blasted index cards of reasonable doubt all over that virtual bulletin board to drive home the point.
It was so effective.
And what you're saying about, shaking hands with the witness, we as lawyers, something you always strive for is to say just enough so jurors draw a conclusion in their mind without us even having to say it, or so that they're thinking it before we even say it. And we saw that, I thought, a lot in Jackson's closing, the way that he did it. He seemed designed so that the jurors were answering the questions posed in their minds before he finished a sentence. But I thought we also saw it in your masterful cross-examination of their Dr. Wolfe, the way you had him go through his typical day, such that the jurors were already thinking about the fact that he doesn't do anything related to autopsies or examining a brain after death or, all of these other things. Was that part of the purpose of the walking him through the day, or was it just to lock him in before he knew where you were headed, or was it a little bit of both?
Yeah, it brings a smile to my face, your question. And it started with Dr. Scorti Bello. You may recall that on cross-examination of Dr. Scorti Bello, I said, would you have, and I had to walk gingerly because I wanted to see if she would know where I was going. So would you have a cardiologist perform an autopsy?
Right.
And she kind of looked at me like I had 4 heads.
And by the way, we put up starting with her, probably, I put up comments and we interjected and said, this is a classic example of the defense using the state's experts as their experts. I've said that more throughout this trial than I have through any other trial, but sorry, go ahead.
Oh, no, that's fine. And then I saw what her view was, and I said, would you have a neurologist perform an autopsy? And she looked at me again, no. And then I said, okay, I think it's safe ground now for me to ask, would you have a neurosurgeon? Because I knew Wolfe was coming on and he was a neurosurgeon. She goes, no. And I said, he's not qualified. Yeah, they're not properly trained. That's where the seed was planted. Yes. So that when I got to Wolfe, and just so you know, when it came to Wolfe, I had a long cross-examination, prepared my outline for that. And I sat there, and I most of the time sat in number 1 seat, which was in direct line with a witness. And I was the closest to the jury. I was literally like 3 feet away. It was such a small courtroom. And I felt the power of his testimony, not so much the substance, just his delivery. Right. And I watched the jurors and they were mesmerized. Mm-hmm. And so I just made an on-the-spot decision that I'm just going to totally do something different. Right. And come at him a different way. And it was all to the point that I had seated. And so, yeah, it was very purposeful. And I told the team, I said, listen, I'm going to have a very unorthodox way to begin the cross-examination of Dr. Wolfe. Just bear with me. And I said, there's a point to it. But when I went through all of that and sat there and let him go on and on and on about his typical day, and then this is his typical 7 days, typical 30, yes. And then when I hit him with a question, I said, well, geez, doctor, and I said, that's impressive and what you do each day. And then what I said, but I didn't hear in all of that any part of your day was acting as a forensic pathologist. And if you watched his face, he first smiled. He looked, he was like blank for a minute, then he smiled, and that smile was, oh boy, I've just been had. And then he got a little angry. Well, if you would have just asked me that question in a straightforward manner, I would have told you, no, I'm not a forensic pathologist. But it's as you know, as trial lawyers, and you both try at a high level, you just have to make intuitive, on-the-spot decisions, read the room, sense of what's going on. You're not always right, but you go with what's best there. but that was extremely strategic as to what I did with cross-examination. And then just picking 3 or 4 items, the laceration on the eye couldn't have been caused by a fall backwards. And then just the gift he gave, which is, oh yeah, I worked in Minnesota, it was cold, and I can't tell you how many drunk people would come in the ER with these counter coup injuries and fall on the back of their head. And it's just like, that's when you just stay quiet and accept the W and just go on to something else. And again, those are just on the spot decisions that you make. But thank you for bringing up Dr. Wolfe. It was a very enjoyable cross-examination. And if I would have hit him head on, I probably could have at best tied. I might have lost a few teeth along the way, but the way I did it, I avoided tooth loss, and I think achieved the objective.
No, absolutely. Once he said, part of his day was I went and I took my wife her cappuccino or whatever. Oh,
I went home at 6:30, at 6 every day, and I make her cappuccino.
And I make her a cappuccino. Everybody loved that guy. And, you know, he was the most credible witness that they put forward, but he helped the defense more than he helped the prosecution at the end of the day, thanks to your masterclass.
And that's what I was going to say. I mean, that moment in time when he let slip with his practice up in Minnesota, and, you know, how many people he had seen that had been drunk and slipped on the pavement was my favorite part of the trial. It was just such a huge win. I loved it. And kind of, when you were preparing your crosses for all the witnesses that had been carved out for you, who were you most looking forward to crossing based on what you were able to uncover in terms of your research into that person? Who were you just chomping at the bit to get to?
You know, the easy answer is all of them, but I will tell you the 2 that stand out the most. The first one was Dr. Scordi-Bello, because I really thought, in the theme that I put forward to the defense was, I said, I'm going to have a completely different approach than you had. The first trial was basically just a few questions of her. I said, I'm going to try to shake hands with her, and the team was great. And so that was the one I was most looking forward to. I'm a clinical pharmacist, so I know the medical area, and there was a lot of areas that I thought were ripe for benefit. So in a non-traditional cross where you're looking to destroy the expert, this wasn't that. I was excited to see if I could shake hands with her on the major issues. Yep. On the other hand, the one I was looking forward to the most was Jessica Hyde. Jessica Hyde had, I thought, tuned up the defense a little bit in trial 1. Again, it's subject matter to the extent people could understand it. She was very professorial, very confident, and I was very much looking forward to that. And we sort of had the battle of who was going to appear the nicest to the jury when we were going back and forth and asking questions. But I started out with her, and I was looking most forward, and I leave it to others as to whether it was effective. I picked 4 mistakes that I found in my research that she made. And she's not the type of person that believes she makes a mistake, let alone 4 of them. And I started out and I went through each one of them. And that was an enjoyable part to me, to get her back on her heels. And then in the end, she shook hands with me, like on, those phones should have been in a Faraday bag. And perhaps one of the most fun moments for me was when I was making the point about the Faraday bags and how they just missed John O'Keefe's phone and just mishandled it. Do you remember when she fought me, but I cornered her and got her to agree that this was a problem and why? She just almost, in a Tourette-like way, after she had to concede, she looked over to Hank Brennan quickly and mouthed, but in a stage whisper, sorry. I don't know. She said sorry when she had to make the concession.
Yeah, we were trying to figure out what was going on. Like, what was that?
Yeah. Listen, I had a better view, obviously, than you. But when I saw her lean in and say sorry to Hank Brennan, that's when I knew she and I had shaken hands on a key point, after having started out with pointing out 4 of her errors. And, I would, out of the corner of my eye, watch the jury as these things would occur. And the jurors were extreme poker players. Boy, they were very, very hard to read. But when events like that occurred, some of them took notice, and so that was fun. So, Bob, it's Dr. Scorti-Bello for shake hand reasons, Jessica Hyde, just because she's just purported and in many instances had such knowledge of the area she taught. She went to great schools for what she did. She was in the military, and it just being able to break down her confidence a little bit and then get her turned around in the end on the Faraday bag stuff was rewarding.
Yeah,
Right, and I know we got
I forgot how much I loved that cross-examination. I affectionately referred to it as a nerd war on our streams because it was two brilliant minds. Because say what you will about Jessica Hyde, she knows her stuff. She's
absolutely
a highly intellectual woman, and to watch the two of you who clearly had a respect for one another, even during the battle of a cross-examination, I could sense that you had a respect for her intelligence. And that's not to say that you treat all witnesses with great respect and great regard, but in that one in particular, I loved it. Like I could not get enough of it. So on the other hand, we have Shannon Burgess. So when do you end up discovering these issues that he had with his CV and what he was reporting in terms of his education level? When did you discover that? Was that 11th hour, or did you know it for a long time going in? And what was it? That had to have been a lot of fun.
Yeah, there were external discoveries and internal discoveries, I'll leave it at that, that contributed to that. It was not long in advance of the cross-examination. Let me give you a range to be a little bit obtuse. It was between 2 and 4 days before the cross-examination. Wow. And the cross-examination was well on its way to being prepared. I had planned on, even with the information, maybe 45 minutes or so for cross-examination, but it blossomed in my lap. And I didn't want it to end. I was, if I could have, I would have tried to have that go 3 days just on his credentials alone. But 2 points on that. One of the most trying things in trial work, as you know, is tricky evidentiary issues. And I had to, for Burgess, do something that I've seldom had to do. And that is I had to, on an expert of the other side, authenticate and then lay the foundation for admissibility of his credentials, like on weird things like LinkedIn. And so there were just very challenging evidentiary issues. And Attorney Brennan and Judge Cannoni certainly put me through my paces. I taught law school as an adjunct for 5 years, and one of the courses had a heavy evidentiary basis. And you may have seen it. I stood next to him. I had no outline, nothing. And I was just doing all of the authentication and foundation off the top of my head, and then pivoting from the objections, some of which were very well stated objections, just with the difficulty of trying to get him to authenticate and lay the foundation for some documents he said he didn't see. Well, fortunately, I got every single one in, so it took a little bit longer. But I got to tell you, as an attorney, those days come very infrequently when you get something like that. And when they come, you better make sure you take full advantage of it. So I just couldn't believe the answers that I was getting either. But again, it's my style. Others might do it differently. I wanted to remain respectful to some degree of him and how I was doing it. Because Allison, you make a point that I taught and I make all the time to associates in my firm. I'm a big believer in not slamming the jurors' faces into the conclusion that you want. Get them there, let them make their own conclusions. Don't leave it obtuse so they don't know. But I find it's been proven out, and I do a lot of jury focus groups for bigger cases, bigger cases in terms of monetary capabilities.
Mhm.
Jurors are more firm when they come to the conclusion than when you just keep forcing it and repeating it on them. And that's the approach I generally take in cross technical experts. You have to go a little further just because you have to make sure the jury understands. But with Shannon Burgess, there was no need to do that. It was, listen, it's a person's career at stake, his career, so I don't wish bad things upon him. But as a defense attorney, those are the moments you get rarely in your career. And if you can get the evidence in and do it right, it can be, dare I say, a lot of fun.
Okay, and I know we've got to let you go, but I have to ask this about the damn x-rays. I've still I can't get over the x-rays. So when he says on direct this thing about there are no x-rays of the arm and there could have been a fracture, are you thinking, wait, there are no x-rays of the arm, or are you thinking this guy just lied to the jury?
Well, if I could, Allison, that whole discussion came out on my cross of Welcher,
Okay.
where I was basically saying he has no broken bone, blah, 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 blah. And he said, well, we don't know that. And I, just to shortcut it, asked a few more questions. And he was like, well, there were no x-rays taken. And I basically, a lot of Welcher, my cross of Welcher, was to plant seeds for the direct of Rentschler and Wolfe. And I know some of the trolls would say, oh, Alessi was going through using his physics background, talking about Newton's first law, Newton's second law, force equals mass times. Hey, guys, just showing off. Well, just get to the point. But it was all setting up because I knew Rentschler and Wolfe were going to come in and talk about Newton's first, second. But this whole thing with the broken bones is Welcher did it, and I just kept giving him more rope. And if you go back, not that you would, and look at it, he started out with, I don't think, there are any x-rays taken. And then I kept tweaking him, knowing his personality, what he would do. And then he just came out and absolutely said, there were no x-rays, so we don't know if there were broken bones. Once I got that, I just smiled to myself and moved on to the next topic.
Just waiting to slam them with it.
It was so good.
Later.
It was so good.
All right,
we were talking about that on our channel when we were streaming it. It was like, because you have the opportunity at that point to absolutely bury him by bringing the x-rays.
But he knew, like he said, he knew the guy's personality, so
Right.
he's just going to let him hang himself and get it in elsewhere.
Yeah, he fought on everything absurdly. So to me, it was like other approaches. Go as far as you can, and then you say, okay, what is the best impact to the jury? To hear me win a cross point after a bloodbath, or that might be a little clunky too, or to just plant the seed, lock him in, and then let our experts sing the song like an orchestra and have it come out so smoothly and logical. And this jury was very, very smart. And just have them sit there and say, look at the x-rays as we're going through it with our experts, say, what? The guy said there was no x-ray, no broken bones. And did you see the size of those x-rays? Right. They were the size of a mural on the size of a skyscraper. We made sure those x-rays were very big so there wouldn't be any doubt as to who could see what.
Yeah, there's no question.
The state,
the latter
perfectly
was
right. But
that.
the state let false information be presented to the jury and didn't correct it. I mean, do you think that there is that the Massachusetts Bar of Overseers, whatever, is going to be looking into things like the holes in the jacket, like all the things that happened at this trial that gave everybody grave concerns, or no one's looking any further and it's over?
Unfortunately, I think it's the latter.
Yeah. I mean, we can laugh and smile about it now because Karen
got the right result.
Acquitted. Had that not had happened, we're all having much different conversations here. And the grave concern is just omnipresent, because like, and that was another discussion Allison and I had kind of like ad nauseum about whether or not Hank knew, like, because it's like you said, Bob, like with the hoodie, you know, maybe he didn't know, but there's no
He
excuse.
put it in a giant glass case on both sides.
Right.
To me, he was
both
planning on
people at the
pointing that
table
out.
knew, and the same goes for the X-ray issue. I mean, if Hank is coming in and he's going to claim ignorance, that he didn't know that they existed, and he asked the question anyway and put it out there that there were no X-rays knowingly, that's one thing. If he did it unwittingly, it's still the same issue. You still have Lally and McLaughlin sitting there who certainly
like a
know that
huge
there were
thing
X-rays. There was just
somebody
so
didn't send the guy X-rays, or he lied, and I think someone didn't send him to him.
one of the two.
All right,
Yeah,
we got to let Bob go. Ask about his
all right, yeah, I'll
podcast.
start wrapping. All right, so before we let you go, there's a couple of things I want to touch on. First, you teased us all with this podcast that you and David Yannetti are going to be bringing out. I'd love to hear a little bit about it. Can you kind of give us like the 30,000 view, give us a little teaser in terms of what we can look forward to? Because we're all dying to hear.
Well, first of all, thank you for the opportunity to talk a little bit about that. I think it's going to end up being a little different than, for example, your podcast and others. You all do it at a very high level, and I don't know if I would get to your level. We're going to be talking about a lot of different topics. I don't think we're going to be covering cases per se. We'll be talking more perhaps about lawyering. I've opened it up on my X account, asking people for their ideas. We've got some very clear ideas, but and my daughter Laura, who's very, very skilled in this area, is helping us, as her significant other Evan is. And then we've got an engineering team from Las Vegas to try to make it look professional. But I think in terms of the teaser, Bob, for topics, we're going to go pretty broad based. We're definitely not getting into politics, but getting into all that goes behind it, how lawyers prepare cases, how you prepare high stakes cases, social media, and how you try a case and with social media in mind. We'll talk about workout regimens. We'll talk about how you get through a trial. And my big view is I love people. And I always try to improve. And I'm going to be talking about things about what I call micro disciplines, macro disciplines in life, things that have served me, errors I've made, how I've overcome them, how I pivoted, changed things in middle of trial, but also all the things that go into being a trial lawyer, because it's grueling and there's a lot more that are at play. And I'm just hopeful that I'll be able to field questions and talk about things that work for me. And if I can help people get through the journey of life a little bit easier, and they can hear about how I've done things, make their own judgments. So I'm looking overall in terms of a broader purpose of, I've had a lot of great life experiences. I've been presented and blessed with many opportunities, great mentors, as I mentioned earlier. And part of my goal is just to share some of that. And if that can benefit people and help them go through their journey of life better, that'll be rewarding to me. So that's a little bit of a teaser. And my last point is David Yannetti is one of the most skilled criminal defense attorneys I've come across. He's got, as I've said, he's got Riz Plus. His connections with jurors are just off the charts. And on top of all of that, he is one of the greatest human beings you will ever meet in your lifetime. And David Yannetti, I am very hopeful and expecting, is going to share all the reasons why David Yannetti is David Yannetti. And I think people will just be as astounded as I am every interaction I have with him, and just learn how to be a better person. And so that's what the podcast is going to be about, and hopefully a little bit more, and hopefully we land it right for people.
It sounds like something to look forward to. About when do you think you got started?
Yeah, so I think we're shooting for a little bit after Labor Day, but we may do also something unorthodox. We may come live a little bit earlier and just sort of talk real time about our planning for the podcast and where we are and what we're doing and just how we're going about it. And, maybe people will say, yeah, that's a great way, or geez, don't do that. And
No,
then,
no.
we'll do, but I think we're going to go maybe a little bit earlier and just
Yeah.
start talking a little bit about it.
Well,
I will
that's a
tell
great
you,
idea.
people love behind the scenes stuff. They really do. And with you two, it's just it's going to
And your
be
bromance.
it's gonna your bromance. It's gonna be fabulous, and it'll be. I mean, I have a hard time listening to people for extended periods of time. Both you and David are exceptions to that rule
Very
in terms of,
compelling.
I'm
Thank
talking
you.
specifically for enjoyment. So I think it's going to be absolutely spectacular. I'm really looking forward to it. Hopefully, hopefully I'll have you guys back on when that thing drops, and we'll just talk about the pod, because it sounds like it's going to be great. And there's just so much ripe stuff that you guys can get into that I think it'll be a really, really great.
Sure, it'll be
great
highly
idea.
successful. Well, thank you so much for joining us, for taking your time out, talking to us and all our viewers. We appreciate it.
Yeah, and I say this to a lot of people, Bob, but for you, I truly, truly mean it. You truly are a gentleman and a scholar, and I could not be more thankful for you coming on with us tonight. You're a great listen, and you're wise beyond your
You'd say
years.
beyond your years, but
Yeah,
I mean-
I had a little.
I've got a
thing
few years behind me.
I had a little joke I had written up that, during the live stream, that I kept having to wipe off my computer screen because people's minds kept blowing up when I kept saying that Bob Alessi's 67 years old. Everybody's brain was exploding. So I kept having to, so I mean, you look fabulous. Your mind is as sharp as a tack. And
But I know we're letting him go, but I didn't ask this, and I'm going to die. So this whole thing about not sleeping, all right? As
Yep.
I've gotten older, I have found if I slack on sleep, because I tend to work to, late hours at home, that my brain works slower, my thoughts come slower. Do you ever wonder if you would be like even more like if you slept, for God's sakes, like what your brain could be on sleep? I can't even imagine.
Well, I've done some empirics on that, and you're absolutely right. The more sleep I get, the better I do. But I've got this odd mathematical calculation that I do. I have calculated that, given the fact that I don't sleep that much, I get to do 1.7 times as much work as anybody else. So I figure that if I'm at 80%, because I'm not sleeping a lot, but it's times 1.7, then I'm doing more work and learning more than if I'm getting the right amount of sleep and just working 1.0 amount of time. So that is my contorted way of trying to justify not getting sleep. But I will tell you this, come Friday or Saturday, especially if I've been doing it for a bit, I'll just end up just collapsing and getting like 7 or 8 hours of sleep. And that's how I know the difference between how I perform when I'm not. But when I'm on trial, it's 2.5 hours a night. And the trial team knew that. They'd seen, because we had to sign in and out of the hotel, the war room. We had a protocol, and I'd be signing in and out at like 4:30 in the morning, and then people would just be shaking their heads. It became annoying to some people because I was overusing the interns. I'd be sending emails out, and in my firm, I have teams that are on all the different coasts to account for the fact that I don't sleep. So I'm emailing people on the West Coast, when I'm up, because otherwise the HR department's going to come after me. So yes, I don't get much sleep, but I truly love what I do. But I do catch up every once in a while, but I recommend it to nobody. And the last point on this, I will tell you, I was doing an associate review of somebody, and I said to him, what I always do is I said, anything else you want to say? And the associate said to me very, very politely, he says, Mr. Leslie, please don't take this the wrong way, but when I grew up to be a lawyer, I don't want to be anything like you. And he was referring to my sleep. He was referring to my sleep.
Obviously.
I would have more balance, a little more balance.
You
should look into these sleep chambers. I know from going to concerts that some of the musicians, they have these like sleep chambers for them because they're
Like
not getting a lot of
hyperbolic
sleep.
chambers.
And I don't know, somehow it's supposed to.
I nap. I'll take a 30-minute nap, sometimes involuntarily. Genetically, I've got this Cro-Magnon forehead that's got about 3 millimeters extra. That's why we're all boxers. And sometimes I'll just wake up and, my head's literally, we just fell right on the table. But I do nap, and nap's great. And I found something else that's amazing, and that is guided meditation. I know everybody knows about it. I was late to the game. And I got to tell you something. You do a guided meditation and it makes you feel like you slept forever. And for some reason, I'm susceptible, fortunately, to guided meditation. So that's what I call it, a little bit of a cheat. Guided meditation makes you feel like you slept more than you have.
Yeah,
and
I
really
guess that's the
focuses on
same
the
that these sleep
breathing.
chambers do anyway.
Yes,
breathing
sleep
is
chamber sounds like it.
So this is the last thing. There was a vicious rumor out there, and I want you to confirm or deny it, that you are really AI, and that every night you just go home and you plug in. And it was actually our friend of the show, Will the Glarer. He's like, I'm pretty sure Alessi just goes in and you download all the data. Is that true?
Are
Or
you
is that
AI?
not true, Bob?
Well, first of all, let me say Will Blair is a great guy. And, in that picture, we were at a certain event and we were both walking down the stairs and I can't remember how, but it wasn't my idea, but somebody said, we want to pose down because Will's got biceps that are like the size of sequoia trees. And so somebody said, well, let's do a pose down. So I'm like game for anything. So and they snapped it, and then it goes viral. But Bob, to prove to you that I watched your show during the trial in Allison, I remember you were on with Mark Betterow, just another absolutely brilliant attorney.
Yep.
And I heard you say something similar, like, yeah, Leslie, I think it's like Matrix. He just at the end of his night, he goes and he plugs in, and I took that as a high compliment. Thank you.
It was meant as such.
Yeah, but the answer is I don't do that. But I will tell you, if you ever find a way for that to work, I'd be the first one to try it. But I haven't gotten to that level. Genetically, I will tell you that my great grandmother had a photographic memory. One of my daughters has close to one. I've sort of got like half of one, and that sort of helps. And just because I love science and math, but I take it as a compliment. But I don't rule it out if it's going to happen. And maybe Elon Musk will create a chip for me that we can talk about that in 5 years.
There you go.
Hey, and when you and David want to talk about the quandary of whether or not AI is going to be the end of human existence, I'm your guy.
Yeah, me too.
I have long thoughts on that. I think we could have a really fascinating conversation about that. But
I love that. Our firm's the leader in AI and law, and we're widely recognized in that. And there's a lot to talk about in that topic.
Indeed, there is. Bob Alessi, you're a gentleman and a scholar. Hey, before you go, where can they find you on Twitter or X? What's your account? Let us know.
Yeah, do you have a name for your podcast?
Yeah, well, we're working on a name for the podcast. We're almost there. And thank you, Bob, for your question. I understand it's to my benefit. It's at Bob Alessi on X.
Can't get any easier than that. Can't get. And for the record, when Laura posted about the podcast, I had thrown a title in there. It was what was it? It was pretty good. It was two lawyers walk into a courtroom. I thought it was pretty good. So
I thought it was very good.
All right. Thank you so much
again
for giving us all your time, Bob. We really appreciate it. We really enjoyed this. Thank you so much.
I enjoyed it tremendously also. Thank you very much. Bob.
All right.
Thank you.
Bye. All right.
That's
Bob Alessi. All right. Ellen Victoria Olsen, no. Very generous Dutch money. What a dream stream. This is magical. So thank you. All the way from Denmark. Ellen and Free Jamie Snow. P.S. Thank you, Allie, for giving me strength and light for ladies going through the stuff that we're not given the memo about. It really helps. I was almost going to say it when Bob was like, you guys said something about like forgetting something. Oh, forgetting a concert from drinking. I was almost going to say, well, I can't remember the concerts I've gone to just because of my fog brain.
Well,
But yeah.
babe, and I have to tell you, I have to make this admission. My man crush on Bob did not get any lower after our interview with him. If anything, it's heightened.
Yeah, I would. I assume so.
He could
Kim
just carry
says,
him around. Like I could just be in his pocket and he can carry me around and just pull me
yeah.
out occasionally.
And
And
I popped Kim's up when he was on there on behalf of the nation. Thank you, Attorney Alessi, for being you. Thank you, History and Homicide, for gifting a membership. Laura A, I did put that up and let Bob know. Julio says, I just got a jury summons for August, and I'm so excited to teach 11 other people about the burden of belonging to the government and the Constitution. So, got to check
love it.
yourself during voir dire, though. You want to come off too strong. Got to
We
get
love it.
yourself picked. Amy's.
Oh, you know what I forgot to ask him? I forgot to drag him into Richard Allen's case.
Yeah, there was tons of stuff. We ran out of time. I was trying to tell you, I was thinking early on, like, oh, we needed to cut the back, like just the fun stuff. But you can only do what you can do. Amy, Positive Pathways, Italian, Scottish, Native American here, Loud House.
That's what I'm supposed to be. Like I have a tragic story about my alleged Native American, my indigenous, that I've thought forever that I was, that may be dashed, but I'm still holding out hope.
You could do your own 23andMe. They could.
I'm not getting
who
on the
knows?
grid.
I know.
I'm not getting on the grid.
Sunny D became a member. What'd she get, babe?
Family hug. Welcome.
And that was Jennifer. I saw this and I went to ask him if he worked any wrongful convictions, and I just didn't get a chance. There were many of you advocating for Jamie Snow.
Hey, before people start dropping off while we're going through the supers, please remember to subscribe, share, and like. If you're on Replay Crew, please leave a comment. It really helps get this out into the algorithm. We feel like it was a pretty good interview with Bob Alessi. Help us get it out there, and we'd love to have you come back. We think we put out some pretty good content. All right, moving on. Thank you.
All right. So Equality says, super serious question. Is there anything Mr. Alessi can't do? I think
doesn't seem like it.
There's not.
Doesn't seem like it.
That girl. How do you control
he's
your emotions with all the objections? I tried to build that in, asking about controlling his emotions with the denial of motions where he knew it was right. I did see that. So Joe Schmo gifted 5 memberships. Thank you. Sherry D, or is that what it says?
Yeah, Sherry D.
I gotta stretch this thing out. I can't see.
Just don't read it on the screen, Bay. Read it.
Oh yeah, I always do that. Okay.
Yeah, it's bigger.
Julio, we popped yours up. Was the Burgess CV situation your first time you had seen that? We brought up the Burgess. I'm pretty sure it was.
Burgess.
Burgess.
Not that you need to pronounce his name properly, but
Burgess. Sorry.
Just in case he's watching.
Unredacted became a member. What's Unredacted get?
Aw, family hug.
Welcome. Stephanie Loomis says, Mr. Alessi, what a pleasure to watch you 2 times in one day. I was 27 with 3 little kids when I started law school. Some of us just take a bit longer to embrace our passion.
I love that.
Yeah.
And thank you for your generosity.
Yes. Smurf Anna, how does Alessi feel about the Bettero exclusion? We did not get a chance to get into this. Has he ever worked on a 1983 claim in general? And how much did he enjoy the challenge? That part he answered. He definitely enjoyed the challenge.
Yeah.
But thank you for your generosity, Smurf. Aaron Hack, Bob and Allie, I fully admire defense attorneys, and you are absolutely at the top of the list. And Alessi is unmatched. Thank you all. God's work. 1,000,000%.
Thank you. Thank you so much.
Thank you. I popped up the Glares. Love the Bobs and Allie together. Miss you, homie.
We love you, Will.
Yes. The Goodmans, thank you for gifting 1 membership. Mad962, thank you as well. Music to my soul. Did Mr. Alessi think that how AJ dealt with the holes in John's shirt in closing was more effective than an appropriate jury instruction would have been, especially after Brennan didn't respond to it. Yeah, sorry we didn't get to ask him that. I think he, um, I think that he
I mean, he
probably would
wasn't
have,
going to Monday morning quarterback it. Like,
right. I
I
think he
mean,
felt
you
AJ
can't
did.
argue with the result at this point, right? I mean,
Right. And I think that, I mean, I think Music to My Soul's acknowledging AJ dealt with it, in the closing, um,
brilliant.
and
Yeah.
Brennan didn't respond to it. So
Right.
I think that did work. I think that
Yeah.
that did
I
work.
do too.
Despite the look on my face, you're still talking. Member for 4 months. Thanks for your generosity. Has Bob watched any of Lally's testimony? Sorry, we didn't get to ask him.
I'm
And
going
I
to guess.
also didn't get to ask him about the damn whatchamacallit, the mirror of the glass in the
Oh, the
picture.
reflection. The
Yeah,
reflection.
it was in my list.
I had a bunch of shit I didn't ask.
Yeah, I know.
It was.
Please pass the pepper. Bravo, brilliantly stated, Mr. Alessi. Yes, he did brilliantly state
And thank you for your
things.
generosity,
Thank
please.
you. Thank you, PFEN. Terrific show. Remember to hit thumbs up. You guys know I love it when you pay money to remind people to do things to help us.
Smash that like
Smash the
button.
like. Kat Randall gifted Dustman gifted a membership. Thank you. Cassie at Bat gifted
Casey.
10
Oh my
Casey.
God.
Damn it. I thought I had it right that time. I was even like,
I have to pull up that. It's like
I know you've said it
it's not
every
a
time.
story. It's like a short. It's about,
Don't blame me, blame my brain. Gifted 10 Defense Diaries podcast membership.
Thank you, Casey.
Thank you, Casey. Ellen Victoria Olson, no. Again, another generous, more generosity. Bless defense attorneys and bless appellate attorneys. You are the real heroes.
We appreciate
Casey
that.
at Bat. Member for 18 months, you'd think I could get her name right. Discuss Burgess. Oh, we did.
Burgess, we did.
Burgess's
We did
resume.
it.
We did that, and I saw that one.
Still great.
And she gave family hugs. What'd she
Oh,
get
right
back?
back at you. Oh, family hug for you.
Jason McClelland, thanks for your generosity. I knew I lost the case when the sergeant told me he had to discuss the trial with the magistrate, and they both rolled their eyes. I got in the poo because of my slow cross. We got through 5 witnesses in 71 minutes. ROI?
I would think that's return on investment.
Oh,
I don't know though. That doesn't
they
seem
do
right.
it to make your client plead.
Yes. No question.
Yeah.
No question about it.
And then Jason said test. I don't know if that was from some up there, or if he was just
I don't know.
doing a test. Dr. Vonda, thank you. Assistant pharmacist and cop education professor here. How much do you use your pharm degree in your law practice? Sorry, Dr. Vonda. Good question, though.
Sorry.
We saw him use it, at least his understanding of science.
That science background is just ever present.
And it probably comes in very handy if he does any civil cases that involve, obviously, medical malpractice or any sort of medicine issues, or defending somebody, entity, about how they, what they put in their warnings, or how they advertise or marketing, things like that, which seems like might be on his radar. MA on evidentiary issue is the trust me, bro.
Trust me, bro. Trust me.
Laura. Right.
Dixie Dixit.
Mar R became a member. What does she get? And she gifted a membership.
Hey, you skipped history and homicide.
Oh.
AJ handed Buchanan something which had his name spelled incorrectly. Did it call him Bukaki? We approve if it did. I wish I would have asked that.
We'll have to ask Dave when he comes on next week.
We'll ask David. Yeah. Like he's coming on.
So does Mar get, what does Mar get?
Oh, family hug. Well,
thanks for gifting a membership.
She's been fam for a long time.
Despite the look on my face, you're still talking. Did anyone ever figure out what part of testimony M. Hartnett wanted to correct? That's a good question.
That was a good question.
We'll have to ask Dave. Can you write that down somewhere, babe?
I'll take a screen grab of it.
Well, we'll take it from the side. Jason McClellan says, so in the regions, Washington police provide
So in the region,
WA. Oh, that's something in Australia or in.
yeah,
So whatever, they
DPA
provide
police
prosecutors.
Yeah.
Police provide the prosecutors. The professional prosecutor at the DPP are for the jury trials. Cops sit in the list the entire day. I might take up 20 minutes of said day. Oh, and that might take up 20 minutes of said day. Wow, that's interesting. That is different.
That is different.
The glare. I was right about the shoe.
Will's obsessed about the damn shoe.
We'll have to ask Dave about it, but
We'll ask Dave about the
I don't
damn
know, Will. Didn't Will have these people on? Did he ask about the shoe?
I don't think Will's had him on. Will's had him on.
Jason McClellan says, I was taught start your closing and the defense must be a headline like a newspaper. Oh, well, makes sense. Makes sense. Bob Alessi is like, tell the jury a bit about yourself. It's a beautiful sucker punch without the punch. Yep.
Thanks, Jason.
Yep. Music to my soul. If Alessi had challenged Welcher on the x-rays, Welcher probably would have said, oh, they must have been in outer space with the Lexus all
that
this
was
time.
The other question I had written. I was gonna like, while you were prepping for your cross of Welcher, did you ever anticipate that one of his, because like when we write cross examinations, you typically know what the witness is going to answer or what they're supposed to answer. There's no way he could have anticipated that Welcher was going to get on the stand and say that it's possible that Karen's Lexus shot into outer space. It was unbelievable.
All right. Again, we've got, well, I'll just put it and then I'll skip back because I just read this one. Tara Rayner says, the shoes, please, for me in the glare. So maybe we'll have to build that in. When we
first Tara Rayner, it was Brennan let cat out of the bag with Rentschler. He questioned why the x-rays weren't mentioned in his report. Hank hoped they were unaware they existed. How could Hank think that? It's idiotic. This is the second time they tried the case, you know.
Got to note something about the shoes for when we have Dave on.
Yeah, the shoes.
Women doing false memories. She became a member. What'd she get?
Aw, family hug. She's been a member.
Bug Dugger. Woot. Member for 21 months. Thank you for your generosity. 21 months.
Oh, gee.
More of Alessi. Bob, I read at the bat to my second grade class. Very dramatic reading. I thought they'd be so moved, but one kid looked at me and said, sorry for ya.
Did you do a dramatic reading like I read the Betterow letters dramatic? Like that type of drama?
Not that dramatic.
That was very dramatic.
JD said, just catching the end. Got to rewind to the start, but I'm sure it was great. Can't wait to listen. Much love. Love you too, JD.
Thanks, JD.
All right, you guys. Well,
there it is.
Yep.
It's in the books. We finally got Bob over here. So
it's dinner time in the Mata household.
Yeah, it was great. It was great. I really enjoyed it. And he's, like I said, he truly is a gentleman and a scholar. So, all right, y'all, we love you guys. Remember to like, share, and subscribe when you leave. Again, if you're in a replay crew, leave a comment, start a dialogue going. It always helps get it out into the algorithm, and that helps the channel grow. Which we always love. Thanks, Will. We love you, buddy. And remember this, guys. Without you, I'm just an old man.
Talking to his wife. I can't even talk. Sitting around doing some shit.
Bed has been shat. We love you guys. Bye.
Bye.
Hot sun.